School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 2 Business Forms and Legislations. Unit 3 The Partnership Act 1932 Part 4.
Differences with other forms of organization. LLP and partnership. Number 1. LLP is regulated by the Limited Liability Partnership Act 2008, whereas partnership firm by the Indian Partnership Act 1932. Number 2. LLP is a body corporate, whereas partnership is not. Number 3. LLP is a separate legal entity, whereas partnership is not. Number 4. LLP is created by a legal process called registration under the LLP Act 2008, whereas the partnership is created by an agreement between the partners. Number 5. Registration is mandatory for LLP, whereas it is voluntary for partnership. Number 6. LLP can sue and be sued in its own name. Only the registered partnership firm can sue the third parties. Number 7. LLP has perpetual succession. The death, insanity, retirement or insolvency of the partner or partners does not affect its existence, whereas it is not so in case of partnership. Number 8. Name of the LLP to contain the word Limited Liability Partners or LLP as suffix. No guidelines for partnership. Number 9. Liability of each partner limited to the extent to agreed contribution except in case of willful fraud. In partnership, liability of each partner is unlimited. Number 10. Each partner can bind the LLP by his own acts but not the other partners. However, in partnership, each partner can bind the firm as well as other partners by his own acts. Number 11. Every LLP should have at least 2 designated partners and at least one of them shall be resident in India. There is no provision for such partners under the Partnership Act 1932. Number 12. LLP may have its common seal as its official signatures. No such concept is there in partnership. Number 13. In LLP, only designated partners are responsible for all the compliances and penalties under the Act, whereas in partnership, all partners are responsible for all the compliances and penalties under the Act. Number 14. Partnership firm is not required to file any annual document with the registrar of firms. However, LLP is required to file annual statement of accounts, statement of solvency, annual return with the registration of LLP every year. Number 15. Foreign nationals can become a partner in an LLP. However, it is not so in partnership. And number 16. Minor can be admitted to the benefits of the partnership with the prior consent of the existing partners. But it is not so in the case of LLP. LLP and company. Number 1. LLP is regulated by the LLP Act 2008 and the companies by the Companies Act 2013. Number 2. The persons who contribute to LLP are known as partners of the LLP. The persons who invest the money in the shares are known as members of the company. Number 3. The internal governance structure of an LLP is governed by contract agreement between the partners. The internal governance structure of a company is regulated by statute, that is the Companies Act 2013. Number 4. Name of the LLP to contain the word Limited Liability Partnership or LLP as suffix. Name of the public company to contain the word Limited and private company to contain the word Private Limited as suffix. Number 5. Minimum 2 members, maximum no such limit on the members in the LLP Act. The members of the LLP can be individuals or body corporate through the nominees. Private company, minimum 2 members and maximum 200 members are allowed. In public company, minimum 7 members, maximum no such limit is there on the members. Members can be organizations, trust, another business firm or individuals. Number 6. Liability of partners is limited to the extent of agreed contribution except in case of intention of fraud. Whereas in a company, liability of a member is limited to the amount unpaid on the shares held by them. Number 7. The business of the LLP is managed by the partners including the designated partners authorized in the agreement. Whereas the affairs of the company are managed by board of directors elected by the shareholders. And number 8. Minimum 2 designated partners for LLP, and for private company it's 2 directors, and for public company it's 3 directors. Advantages and disadvantages of LLP. Advantages of LLP. Number 1. Easy to form. That is, less legal and procedural requirements. Number 2. Low cost of formation. The minimum fees of incorporation is as low as Rs 800 and maximum is Rs 5600. Number 3. Separate legal entity. LLP and its partners are distinct from each other. Number 4. Perpetual existence. The LLP shall continue to exist till it's wound up in accordance with the provisions of the relevant law. Number 5. Limited liability. Liability is limited to the extent of his contribution. Personal assets of the partners are exposed in case of fraud. Number 6. Flexibility in management. The LLP Act does not regulate the LLP to large extent. Rather, it gives freedom to partners to decide the way they want to run and manage the LLP in form of LLP agreement. Number 7. No requirement of minimum capital contribution. Number 8. No restrictions as to maximum number of partners. Number 9. A partner cannot bind the other partner for his act. Number 10. Easy to dissolve or wind up. And number 11. No requirement to maintain statutory records except books of accounts. Disadvantages of LLP. Number 1. The documents filed through the Ministry of Corporate Affairs portal are public documents and any person can access them by paying a nominal fee. Number 2. LLP cannot raise funds from public. It can either borrow debt from financial institutions or via loan from partners. Number 3. Any act of the partner without the knowledge of other partners may bind the LLP. And number 4. No separation of management from the owner. Incorporation of LLP. Prerequisites for incorporating an LLP. Number 1. Minimum 2 partners, that is individual or body corporate. Number 2. Minimum 2 designated partners who are individuals and at least one of them should be a resident of India. Number 3. Digital signature certificate. Number 4. LLP name. Number 5. LLP agreement. And number 6. Registered office. LLP incorporation process. The Ministry of Corporate Affairs or MCA YD its notification dated 18 September 2018 made major amendments in the rules for incorporation of LLP YD Limited Liability Partnership, that is Second Amendment Rules 2018, which came into force from 2nd of October 2018. The highlights of the amended LLP incorporation process includes the introduction of specified LLP run services similar to RUN or run service for company incorporation, for reservation of name for the proposed LLP, Form FILLIP and Form Philip, that is Form for Incorporation of LLP. Form Phillip is similar to Form Spice for company incorporation. So the major steps are: Step 1. Procure digital signature certificate. Step 2. Apply for name approval. Step 3. Preparation of documents for incorporation of LLP. Step 4. Fill the information in form, that is Phillip. Step 5. Certificate of incorporation. Step 6. Apply for PAN and TAN. And Step 7. Preparation of LLP agreement. Now we will elaborate these steps. Step 1. Procure digital signature certificate or DSC. The first step towards registering LLP is to procure the digital signatures with validity of 2 years for the designated partners. A digital signature is must because every form is filled online with the Ministry of Corporate Affairs and each requires to be signed digitally by the applicants and partners of the LLP. The DSC is associated with the PAN card of the application. Digital signatures required can be obtained from certified government agencies such as National Informatics Center, IDRBT Certifying Authority, eMudra, CDAC, and NSDL. The cost of acquiring a DSC will be according to the certifying agency that the applicant has applied for. Step 2. Apply for name approval. To register a proposed LLP, the applicant needs to get a limited liability partnership reserve unique name, that is LLP run, that can be processed at the Central Registration Center. However, before citing or quoting the name, it is always advisable to check from the Ministry of Corporate Affairs or MCA portal for a free name. The new process requires the applicants to file the web form named Run LLP, that is Reserve Unique Name Limited Liability Partnership. Run LLP replaces the old Form LLP Form 1. The new form has been simplified that requires information related to the desired name, its significance, and other basic details. The application can be made with maximum 2 names in preference order and providing their significance. The names must comply with the provisions for the name reservation. If none of the names is approved by the MCA, another chance is provided to apply for 2 more names. The government fees for run as per Register Office fees rules shall be ₹1,000. DSC and DIN are not required for filing of run form for reservation of name, but account of MCA portal is mandatory. The name allotted under LLP run will be reserved for a period of 90 days. If the LLP registration application is not filed in given period, the name will expire and it can be reserved through new application. Step 3. Preparation of documents for incorporation of LLP. After approval of name, LLP applicant is required to prepare certain documents. They are: Number 1. Proof of office address, that is conveyance or lease deed or rent agreement etc. along with rent receipts. Number 2. NOC from owner of the property. Number 3. Copy of utility bills not older than 2 months. Number 4. Subscription sheet including consent. Number 5. In case a designated partner does not have a DIN, it is mandatory to attach proof of identity and residential address of the subscribers. Number 6. All the DPs should have digital signature. Number 7. Detail of LLPs and or companies in which partner or designated partner is a director or partner. And number 8. Copy of approval in case the proposed name contains any word or words or expression or expressions which requires approval from central government. Step 4. Fill the information in form, that is Phillip. Once all the mentioned documents and information is available, applicant has to fill the information in the e-form called Phillip. that is, Form for Incorporation of Limited Liability Partnership. This is a major change in the new process. Philip replaces the previous Form 2. Earlier, if a person wants to incorporate LLP, then he or she had to apply separately for the DIN, that is DIN, approval of the name availability, registered office address, etc. But this form is a single window for incorporation of LLP and it can be used for many purposes like application of DIN, application for availability of name, and no need to file separate form for address of registered office. Only 2 DPIN and DIN can be allotted through Philip. In case there are more than 2 DPs or DPs are to be changed, the respective partners are required to obtain it by filing DIR3 after incorporation. The e-form is to be attested by the partners through DSC and certified by the practicing chartered accountant or company secretary or cost and works accountant. The application will be processed for approval by Central Registration Center or CRC. If the registrar finds it necessary to call for further documents or information, he may do so by directing for resubmission within 15 days. Another opportunity of resubmission may be provided after re-examination of application, which again has 15 days period. It is provided that the total period for resubmission of documents shall not exceed 20 days in total. Step 5. Certificate of Incorporation. Once the registrar approves all the forms and documents, the Certificate of Incorporation or COI is issued in Form 16 along with DPIN and DIN allotted to the designated partners. COI will also consist of the Limited Liability Partnership Identification Number, that is LLPIN. Registrar of Companies or ROC assigns a Limited Liability Partnership Identification Number or LLPIN for every LLP which is registered. The date of COI will be the date of LLP incorporation since when it has come into legal existence. LLP is now entitled to commence business in its name. The Certificate of Incorporation shall be the conclusive evidence that the limited liability partnership is incorporated by the name specified therein. Step 6. Apply for PAN and TAN. Soon after getting the incorporation certificate, the application for PAN and TAN is required to be made separately for LLP through offline or online mode. The applications are made directly to the Income Tax Department and also processed by it. The applications are made in Forms 49A and 49B respectively with the Certificate of Incorporation as supporting proof. And Step 7. Drafting and filing LLP agreement. The next step is to draft LLP agreement and other documents for registration. An LLP agreement is essential as it determines the mutual rights and duties amongst the partners and between the LLP and the partners. The agreement must be filed with MCA within 30 days of date of incorporation. The delay leads to a penalty of ₹100 per day till the date of actual filing. LLP agreement contains the name of LLP, name and address of partners and designated partners, business object, place of business, and other details of LLP. Other clauses will be form of contribution and interest on contribution, profit sharing ratio, rights and duties of partners in case of admission, resignation, retirement, cessation and expulsion, proposed business, and rules for governing the LLP. Once the LLP agreement is reviewed and agreed upon by the partners, it will be executed by payment of stamp duty as applicable in the state where the registered office of the LLP is situated. Then, with signature by partners and attestation by the witnesses, the agreement will be executed. Now let's summarize the unit. Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any one of them acting for all. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which the business is carried on is called the firm's name. The true test in determining whether a partnership exists is to see whether the relation of mutual agency, that is, principal and agent, exists between the parties or not. Registration of firm is not mandatory but desirable, as an unregistered firm suffers from a number of disabilities. Based on their conduct or profit sharing, partners can be of different types like actual, active or ostensible partner, sleeping or dormant partner, nominal partner, partner by estoppel or by holding out, and so on. A minor cannot be a partner, but he can be admitted to the benefit of partnership with the consent of all. He has right to share profits, but his liability is limited to the extent of his share, and he is not personally liable for any losses. The rights and duties of partners are governed by the agreement among them, but in case of absence of the same, the provisions of the Partnership Act are applicable. Unless there is a contract to the contrary, every partner is a joint owner of the property of the firm. Every partner binds the firm for the acts done within the scope of implied authority. A change in the contribution of a firm takes place on admission, retirement, expulsion, death, or insolvency, and transfer of interest. The dissolution of partnership firm may be without the order of the court or voluntary dissolution or by the court. After dissolution, the rights and obligations of partners continue in all things necessary for the winding up of the business. The partners may complete unfinished transactions, but this authority is only for the winding up of the affairs of the firm and not for new transactions. Limited Liability Partnership or LLP is a body corporate with separate legal existence, perpetual succession, and a common seal if it decides to have one. It is mandatory for an LLP to register with LLP at the end of its name. The rights and duties of a partner and the partnership are governed by the agreement to the same. LLP should have at least 2 members and 2 individuals as its designated partners, one of whom should be a resident of India. A firm, private company, unlisted public company can also be converted into an LLP.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.